So I'd like to thank Elsa Manqui and Desai for 3 really terrific papers. I think these papers put us firmly in 2 areas, one of which we've touched on before and one of which is new, at least for this conference, the effects of mobility and migration on the ability of workers to be protected, and the availability, particularly within this context, the availability and challenges of providing appropriate compensation, and that within a context often of a compensation program or a social insurance program that's inadequate. We know, and these papers underscore the fact that workers in motion have increased vulnerability on for a variety of reasons on a variety of scales, that they are more insecure, that they face more informality, more fragmentation, they are lacking information and training, all of this creates barriers to reporting, barriers that include geographic and language issues, as well as general insecurity, barriers to organizing and raising collective voice, and that the likelihood of triangulation and cascading contracting is perhaps plays out in more severe ways in these situations. So it leaves us with a number of questions about what interventions would be effective to address this increased level of vulnerability, at the same time recognizing that people who work in agriculture and in seafaring face huge levels of risk at the baseline. How do we address the issues of creating organized or concerted voice for workers and communities in these kinds of contexts? And it's clearly more difficult. And the specialized problems that compensation holds for people who are in the migratory workforce. We face this in the U.S. as well, particularly where there are multiple cascading parties who are involved, as Desai was describing, but also where people who work in one place and go home across boundaries to another when they're disabled, ill, or old can obtain compensation for work injury and work-induced disease, and those are incredibly complex problems, I think, that would be difficult for us to address in this meeting right now. In any event, with that, I'd like to open it up to the floor for questions and comments, and we will do as we have been doing in the prior panels. We'll take 3 and then ask the panelists to respond and so on. I believe that our next event starts at 3, which is a break, and we started a bit late, so we have a little bit. You think we should go over a little bit, or okay? The master says we can go over a little bit, but I'll open it up to the floor. It's the post-lunch lull.
Hi, it's Steve Mantis with the Ontario Network of Injured Workers Groups. My question is, I guess, directed to Manqui, if I got that correct. When you were quoting the numbers, I wasn't clear whether that was workplace fatalities or whether that was the number of injuries. And of course, the second is a comment. I'm kind of going, how can we support you guys? Like, this is like crazy what's going on, and we are a global society, right? It's not just corporations that are global. What can we do to support you?
Hi, my name is Jean-François Duchamp-Varin. I worked on a paper trying to solve one of the issues we're trying to look at is temporary foreign workers. So I forgot your name, but the first speaker from the Australian case. I was wondering, because there's something that I kept thinking is different in the case of Australia, and it's the I mean, I've been a backpacker for many years in the past, and you have an economic precarity, but it's, you know, it's kind of changing. It's a bit of a choice in some ways. I don't know how to explain it well, but has there been, because I was looking at the list of countries that Australia accept for people, and it's basically, even in the Asian countries, you see countries that have fairly higher economic standards. And then again, I was thinking in comparisons to here in Canada, where you have temporary foreign workers from very poor countries. So they have an increased precarity because of their economic precarity, not only of themselves, and that's the difference with the backpackers, but also to the family that stayed in their country, with maybe Guatemala or another, and that they're in debt. And so they have to keep working in these unsafety conditions, which leads me to the question that, are there any pressures now, because we've seen the same statistics when you were showing that increasingly it's now Asian workers, and we have the same statistics here as increasingly before we had a program where it was mostly Mexico and anyway, it doesn't matter, Jamaica. And now there's a tendency for temporary foreign worker programs to aim at countries that have lesser regulations of their programs, kind of. I'll make it simple. But is there pressure in Australia to move towards increasingly poorer countries, and so that increasingly you have like access to more easily manageable workers? Sorry, tough question.
Why don't we take those two, and the rest of you can think about any additional comments or questions.
Thank you very much for your question. I mean, to be clear, to the first part of the question, you know, the number I've shown on the slides, actually that's the number of workplace accidents. I mean, as I have mentioned, both in terms of, you know, numbers of occupation accidents and occupational diseases, there is a serious problem of underreporting, very serious problem, everyone knows. So I'm not naive to say that, you know, this is a true number, but, you know, it does reflect some of the trends if we assume that, you know, the underreporting rate or the claim suppression rate remains the same. So this is the answer to your first question, to the first part of your question. The second is that, you know, in China now, the the workplace health safety situation is very poor. But, you know, compared with like 10 years ago, it has been changed a lot. I will give you the example with regard to the fatality rate in the coal mining. Like, you know, 10 years ago, like in 2002, that is the most catastrophic year in coal mining history in China. You know, there are many large-scale fatality accidents happening in coal mining. At that year, you know, the fatality ratio in relation to, or the fatality ratio of per million coal produced is 5. So now, after 10 years of enforcement, inspection, investigation efforts, last year the number was reduced to 0.24% fatality per million tons of coal produced. I mean, it's still relatively high compared with in the United States, still like 7 or 8 times higher. But you can see it has dropped a lot. So in this sense, the workplace health and safety situation has been changed a lot. And domestically in China, I think the way to keep workers safe and healthy in the workplace, there are many ways. One way is to raise their awareness. That's what we do. And in China, there are some NGOs who are doing a lot of work in advocacy, to push the government, to push the decision makers, to change legislation. So you can see that's the reason why we have the new law in place, in 2012, 2014. It is good, in terms of, the improved occupational health and safety situations in China. Hope I answered your question. Yeah, thank you.
Thank you for the question around migrant workers in Australia. And yes, you're absolutely right. We're very fussy about who picks our fruit and vegetables, and we like them all to have degrees. And but most particularly, the countries that the government makes these agreements with, one of the considerations is what's the likelihood of the visas overstaying. And so all of the countries that come into the Working Holiday Maker scheme are countries where we think that the travellers will go home at the end of the time, although increasingly the largest group of overstayers in Australia now are Chinese. There is some concern about the 5,000 Chinese who are about to be released to do mostly harvesting work. But again, they have to have 2 years tertiary education, so they're not the poorest of Chinese. The poorer Asian countries, there's a very small entitlement to Thai workers. I think we allow 100 per year, talking really small numbers. The poorest of the Asian nations don't come to Australia officially as workers under these schemes. They do come in as undocumented workers. So there's not a lot of pressure for the government to open up official channels as long as we have a huge number coming through on tourist visas and staying for 1 or 2 years. So that's how we pick up the poorer nations.
See if we can get a mic to Catherine.
C'est-tu allumé? Ça va? So I have a question that I won't ask to Elsa in French, just because I'm her friend. But it's a question, but it's more of a comment and an invitation to all of you and to the people who will be following, including my neighbor here, Marie-Ève, to pay attention to what you said, which was so important, which is that they have to have these 88 days. And if they get their 88 days, then what they perceive to be good things will happen. And if they don't get their 88 days, good things will not happen or bad things might happen. And in different countries, and I don't want to presuppose what you're going to be saying tomorrow about harvesting of shellfish in Canada, rules that are not supposed to be about occupational health and safety are, in the example that you just gave us, are driving occupational health and safety conditions. And they can be immigration rules, they can be unemployment insurance rules, they can be rules involving what you can send back to your family and whether you can bring your family or not, if you think of the domestic foreign worker program here. So it's a comment, and I don't know if any of you want to comment about the way that rules that are supposed to be about something else drive occupational health and safety outcomes. But I would at least invite everybody to pay good attention to the example that Elsa's already given us.
Yeah. That's certainly very true in Australia, and the 88-day target for young travellers can mean the difference between staying on another 12 months, being able to save to spend another 12 months travelling through Asia. So these are really substantial decisions that flow from the 88-day target, and that's why they're willing to do virtually anything to get the jobs. And because they're young, they think they're invincible. So they don't actually see the work as hazardous until something very major happens to them. So it is a really good example of how completely different legislation drives bad outcomes.
I assume this happens in other countries, and in the U.S. There are examples of totally unrelated, non-employment type regulation that have huge impact. So, for example, the Department of Transportation will issue rules that have to do with over-the-road trucking that have secondary effects on rules that have to do with hours and distance and speed. Perhaps in a truly alarming development, the United States Department of Agriculture was looking at issues of safety in the poultry processing industry. That's an industry that is extraordinarily dangerous, and the workers who are working in it are phenomenally vulnerable on every scale that you can imagine, and many of them in the U.S. are now undocumented from Central America. And the USDA's focus on birds, the safety of the meat that was coming out, they were willing to make trades with the industry with regard to the speed of the line. And the Department of Labor and the Occupational Safety and Health Administration found out about this and went to battle over this question of whether the USDA could unilaterally make a decision with regard to the speed of the line that was going to have significant impact on the health and safety of the workers on those lines, particularly in view of the well-documented repetitive stress injuries that exist in that industry. And so those kinds of interactions, actually, where the industry itself has more influence in another department than it may, for example, in the Labor Department, can shape some of the outcomes.
C'est encore possible de poser... Still possible to ask?
Yes, of course.
Thank you. Je suis Geneviève Barry-Gingras, je suis de l'Université Laval à Québec. Donc, ma question s'adresse à Manku. D'abord, je voudrais souligner que c'est très... ça donne beaucoup d'espoir de voir qu'il puisse y avoir quelques changements positifs dans une législation, puisque ce qu'on a vu jusqu'ici, c'était plutôt dans le monde occidental des réglementations de facto ou réelles, hein, c'est-à-dire dans les textes. Donc, il semble y avoir des changements positifs. Par contre, j'aimerais entendre un peu plus de réflexion sur l'idée que ce serait une bonne solution que de fusionner l'indemnisation et l'inspection, puisque de ce que j'entends, c'est plutôt la réflexion inverse, c'est-à-dire qu'au Québec, on a cette fusion-là qui a été faite avec de bonnes intentions, qui était de permettre une meilleure information aux inspecteurs afin qu'ils puissent rapidement intervenir sur les lieux de travail en fonction des indications qu'on recevait du fait qu'il y ait des accidents qui soient survenus ou des maladies professionnelles. Mais ce qu'on a vu, c'est que la logique économique des coûts est devenue dominante et que la CSST s'est présentée elle-même de plus en plus comme une compagnie d'assurance publique avec la logique des coûts de l'assurance qui fait une pression énorme, et que même quand on essaie d'utiliser ça pour faire de la prévention, ça a toutes sortes d'effets pervers. Alors, il y a peut-être d'autres logiques qui peuvent être à l'œuvre, qui peuvent nous laisser penser que ça peut être une bonne idée de fusionner. Mais ce que je vois, c'est qu'il existe quand même au Québec des gens qui ont le mandat d'aller contrôler, donc des vérificateurs, des comptables, qui vont vérifier si les milieux de travail se sont bien enregistrés à la CSST pour ce qui est de payer leurs cotisations. Donc, il est possible quand même de séparer les deux fonctions puis qu'il y ait quand même un contrôle là, de la couverture comme telle. Mais il y a peut-être d'autres expériences ailleurs.
Are there other comments or questions now, or should we allow... It's a very interesting conversation to talk about.
Thank you. My name's Andy King. I have a couple of questions regarding the situation in China in particular. It's in two parts. One is that, Manku, what you described is a national system. And so my question is, to what extent does the implementation of the national system rely on the politics of the province or state or autonomous region in which people are working? I think of this particularly with regards to migrant workers. And my other question to decide regarding compensation, is that a particular system of compensation just for maritime workers? And if it is there any pressure in China to improve it because of the consequences to their citizens, to their to the families, to improve their ability to access compensation either through the creation of here we have systems where it is an independent board that is responsible for collecting the money and making sure they're getting paid. It sounded like the system in China is more of an insurance contract where you still have to deal with the employer directly, you still have to deal with or the organization that the worker was contacted through, rather than a central public institution to address the issue.
Are there any others?
Thanks. One to Mankey. The issue I think that's come up already is I'd like to know what's happening with unions in China as a reform thing. I think that's the elephant in the room. And the other one to Desai, which I really thought was good, and our own study, our survey, which is mainly North American and Australian, is finished and will be finished very soon. I'm very interested that you've got a Chinese perspective on that, and so I'm very interested in the results of that. I wonder, what we found is as families start to split, this creates additional tensions as you get new relationships and so-called mixed marriages, and you have two families fighting over the compensation for one worker. Is there any sign of that happening in China, or is this going to become distinct because of the traditional family structure there? Thank you.
Shall I answer? Yeah. Okay, I have 3 questions to answer. The first one is, regarding about the relationship between compensation and occupational health and safety. I mean, this is a very interesting question. How do we deal with it? We split it up, or we put it in one organization? I mean, here in Canada, it's a very perfect place to work. There are 2 different, ways, like 6 provinces, including Quebec, BC, they rested within one, right? Works BC or CST. Well, in other provinces, like in Ontario, they now try to split up, one with Labour, one with, WSIB, right? So the effectiveness of these 2 kind of system, I mean, it depends. There are many different factors to factor in. Well, my understanding is that, if we put compensation and OHS under one roof, if, as I have mentioned, the coverage rate is very high, like, higher than 90% in terms of administrative efficiency. This system can be very efficient in terms of, administrative efficiency. While you rightly mentioned the question about, there might be some like adverse impact that, like CSST regards itself as this company. So it can process of claim suppression in order to reduce the cost. Well, I understand is that, these do not necessarily caused by this, by this one system or one single organization. It means we should have some critical thinking of financial incentives, like experience rating, whether we should rein in or we should restrict the widespread use of experience rating, because the widespread use of experience rating will increase the adversariness both between the workers' compensation, like CST and injured workers, and also the employer and the workers. So, I mean, by limiting or by reforming the experience rating can reduce the level of adversariness and can avoid a lot of like unintended consequences. So that's my response to your question. My response to the second question with regard to Andy's question about the national occupational health safety system and the enforcement, right? Whether there is like anything related to the provincial factors. Well, my answer is yes and no. So for the first part, largely, it was influenced by the provincial-based, like their enforcement resources and so on. Because overall speaking, the occupational health safety enforcement, or in terms of inspection, that's decentralized system. So it is left to the province to decide. If this province, like in Shanxi province, which have a very bad track record of occupational health safety. Nowadays, they get a lot of media attention, so they do not want this. So they will step up their efforts to change the image, the negative image. So. In that province, it can improve their occupational health safety. So this is largely speaking, it has a lot of to do with the provincial one. Well, the reason why I say no, in one area, coal mining. In coal mining, the enforcement or the inspection system is centralized. It is decided top down. Top-down decided by the central government. So in this case, like, even there is a kind of like, there are also coal mining inspection bureaus, in the province, but they are directly affiliated with the central government. So in this case, for coal mining, it was not influenced by the provincial priorities. So this is my answer to Andy's question. My response to Professor Quinlan's question regarding unions in China. Yes, this is the elephant in the room. I agree. What happens with regard to the trade unions or to the collective bargaining when we're talking about the protection of occupational health safety for migrant workers? Well, as some of you know that trade unions in China, it's embarrassing. My friends from University of Plymouth mentioned that in India there is like management union. Well, in China, it's fair to say in China the union is both management union and government union. So it is neither independent from the employer, because the employer have to contribute a significant part of the so-called membership fee. And it's for the trade union, it is also, especially for the Federation of Trade Union, they are the branch of government, so they are neither independent from the employer or independent from the government. Well, we all know that the interest between the employer and the interest between the employees sometimes they can in conflict. Well, the interest of the government sometimes can also run counter to the interest of the employee. For example, the government want to grow the economy, right? Want to attract investment, especially the foreign direct investment. So how can they attract this foreign direct investment, in all sorts of regions? There is cross-regional competition, right? So in order to attract, this foreign direct investment, like into the Western China, so these provinces have to offer something like, the relaxed enforcement of law, or, the passive role of trade unions, like this. So sometimes, the interest of government and the interest of workers can also, collapse. So in this way, I do think at least now it is naive to count on Chinese version of trade union to protect the interest of the workers. And it happens, as I mentioned, overall speaking, there is a lack of grassroots mobilization in China, right? But it's changing. like in southeastern China, in Guangdong province, they're beginning some like organization activity among the migrant workers, especially the young migrant workers. They will conduct first they kick off the trade union. You are not representing us, and we are form our own organization, and we will engage in working stoppage, and also, or you can create a wildcat strike to demand a pay rise, or to demand the employer to participate in the social insurance. So there are very few so-called organizational activities for the sake of improvement of occupational health safety protection. But I think this can be a positive change in the future. Yeah, hope I answer your question.
Thanks, Andy. Thanks, Michael, for the question. I will address Andy's question first. About the Chinese seafarers' special jurisdiction over maritime injuries. Previously, we have a specialized judicial opinion, legal source, regarding personal injuries and death at sea. That is established in 1992. However, the current workers' compensation system is introduced in 2003. But gradually, there is a pressure from the government who would like to unify both of them. So in 2013, the specialized legal source regarding maritime injuries and death at sea is abolished. So they try to merge the seafarers' occupational injury into the nationwide standard workers' compensation. However, there is a politics between maritime courts and local labor bureaus. The maritime jurisdiction is specialized, I think, also in United States. Maritime in the UK, there are special maritime jurisdiction. So the maritime jurisdiction usually in charge of maritime courts and maritime safety administration. In that sense, the maritime courts wouldn't like to regulate seafarers' issues because it's usually too time consuming and the litigation fee is not very significant, and would like to move that part to the local governments, local labor bureaus. However, the local labor bureaus would always say their jurisdiction over the maritime disputes is not efficient. So currently, these two departments are fighting with each other. And they try to have a compromise to say they have established a new department to deal with seafarers disputes. So both of them would be join that. So, okay. My response to Michael's question about multi-marriages in the compensation claim. In my research, I haven't found a multi-marriage. I think one reason for that is seafarers as an isolated group of workers, it's very difficult for them to have the first marriage. And I do have a case that got divorced. And so in that case, because he got divorced and couldn't find a new partner, he got so depressed and went to sea and died in an accident. So that's the only story I have heard about split family. I hope this answers your question.
Thank you again to the three primary presenters, and it's time for a break. What time would you like to reconvene?